Hello and welcome everyone. I hope all of you are doing well in these trying times. Today, in this particular lecture of company law, we will be continuing with our topic of voting. The focus point today will be on section 110, section 110, which speaks about postal ballot. So, we have so far covered different types of voting methods, out of which was the first one that was show of hands. The second one was electronic means, and the third one was demand for poll. The last one is now, which is what we are going to discuss in this lecture, is postal ballot. So, without wasting any time, let's get started into section 110, which is postal ballot. Now, postal ballot is a method which has been recently started some years ago for wider participation of shareholders into key decision makings. What do you mean by this? See, there are many shareholders who are living at faraway places and cannot come into the annual general meeting. So normally in companies you will find that the participation of shareholders is normally low in the annual general meeting. We have to understand over here that the annual general meeting is a meeting of shareholders. So their participation is extremely important, as whatever proposals are provided by or laid down by the board of directors will get approved by the shareholders in the annual general meeting. Now, since many of them live at faraway places and cannot travel to the registered office of the company or the place of meeting, hence this particular method of postal ballot has been introduced. So you have understood the need for postal ballot and the logic behind it. Next, postal ballot is a method where the company would send a notice of the resolution to be passed to the shareholders through an envelope in which, along with the notice, the shareholders have to reply in writing whether they assent or dissent to the proposed resolution. Once the assent and dissent of the shareholders are received at the registered office, then it will be counted and result will be declared. This is how a resolution will be either passed or not passed. I hope you have understood this introduction of postal ballot. This is the macro view of the postal ballot process. Let us get into understanding now. When do we require to make or conduct voting by postal ballot? So, our next question is when. We have already answered why. Why is something that we have answered. Now we have to answer to when. When do we have to conduct voting by postal ballot? So let us understand it with the help of this particular chart. Voting by postal ballot. Normally, voting by postal ballot are done or conducted in such business items which have been already notified by central government. So there are fixed number of business items which the central government has already notified in its notification that these are the items in which the company has to mandatory, how is it? Mandatory, have to conduct by voting through postal ballot only. So this is mandatory to every company. This is given by central government. Provided that such business, if such business item which is notified by the central government, but the company is also required to provide electronic means of voting facility to its shareholders, in that case, postal ballot will not be required. So provided that such business item, if company is required to provide facility of e-voting under section 108, then such item may also be transacted at the general meeting itself, because we have seen the procedure of section 108 in our last lecture, where the company will give a e-voting facility. At the same time, the persons or members who have not voted through e-voting facility can come to the meeting, that is the general meeting, and cast their vote. So in case section 108 is applicable or has been taken by the company as a route of voting, then postal ballot is not required. So this is something that you have to remember. It is an important point from case study point of view. Okay. Next, list of business items which shall be transacted only by means of voting through postal ballot, which means these are the items which have been notified by central government in its notification that they have to be mandatorily conducted through postal ballot. So let us look at this list. This is a longer list, but let us go through it. It has around 10 to 12 items. You need to remember around 5 to 6 items for examination purpose. Okay. So the first one is, if the company wants to alter its object clause. We know what is object clause. Object clause is a clause which is there in the memorandum of association, and this depicts what is the business activity that the company is going to undertake. Okay, these are memorandum of association and articles of association are incorporation documents of the company. Similarly, if the company wants to alter its articles of association, okay, it wants to change its registered office, it wants to change its objects where the company has raised some money and it is still unutilized, raised some money from public. So it has come up with an IPO. I'd say, for example, it had come up with an IPO of 100 crores. It has so far utilized 80 crores and 20 crores is still unutilized and it wants to change in its objects. Then the company will have to undertake the route of voting by postal ballot. Okay. Next is, if the company wants to issue shares which have differential voting rights, DVR shares. This is covered under section 43 of your syllabus. So please go through it. Next, if the company wants to make some variation in the rights of the shareholders, this is covered under section 48 of the Companies Act. Go through it. Okay. And if you find some issues in these two sections, do let me know in the comment section. I will prepare a separate video for your understanding. Okay. Now, after this, in case the company wants to undertake a buyback of shares is covered under section 68. So in case of buyback of shares also, postal ballot is required. In case of election of director under section 151. Section 151 is in your CA final syllabus. So when you come to CA final, you can go through that video of mine, which is explaining about section 151. So currently, just understand, in case of election of directors, the resolution will be passed by postal ballot. There are two more business items which are again covered under CA final. But for the purpose of conduct of voting by postal ballot, these two items will also be mandatorily by postal ballot. The first one of it is sale of whole or substantially the whole of the undertaking of a company. So if the company has 3 undertakings, any one undertaking the company wants to sell for whatever reason, maybe they're getting a very good price for it, maybe it is a loss-making undertaking. So in case they want to sell any undertaking or a part of it, then in that case, they'll have to take the voting by postal ballot route. That is covered under section 180, subsection 1, sub plus A. And finally, if the company is giving loans or extending guarantee or security, you all know what is guarantee and security. It has been covered under Contract Act. I'll be soon putting in lectures on Contract Act also. If you want those lectures, do comment in the comment section and let me know. So if the company is giving any loans or extending any guarantee or providing security which is in excess of a limit under section 186 subsection 3, in that case also company will have to go for voting by postal ballot. See, there are around 10 points over here. Remember, at least 5 to 6 points minimum. Remember, it is very easy. Alteration of object clause, alteration of articles of association, change in registered office, alteration in objects where money is funded and it is still unutilized, issue of DVRs, variation of rights, buyback of shares. At least these first 7 points you should be able to remember because these are there in CA INTER syllabus itself. Okay, so I hope you have understood this point. This is also important from examination point of view. They may ask you a case study where the first sub-question may be when would the voting by postal ballot be mandatory? The second part of that particular question may be list at least 5 or the business items which needs to be transacted by such means. So you have to write, it will be around for 3 to 4 marks. If you write around 4, 5 to 6 points, it is more than enough and sufficient. Okay. Next part is, so we have understood that first of all, postal ballot will be mandatory in case of business items notified by central government. The second part is any other business item apart from the business items that we have currently gone through, 10 business items that we have gone through. Apart from them, any other items also can be done by the company through postal ballot, provided that it is not an under ordinary business. It is not an ordinary business. Ordinary business has to be done in the general meeting itself, not by postal ballot, not by postal ballot. Also, in case there is any business item where the director or the auditor have a right, director or the auditor have a right to be heard at the meeting, then in that case, it shall be done only in the general meeting and not in the postal ballot. I hope this part also is clear. So there are two parts of it. When would we have postal ballot used? One is business items notified by central government. Other is any other business items which is not ordinary business or in which the directors or auditors do not have a right to be heard at the meeting. I hope this is clear. Now, one more important point is resolution passed by postal ballot will be deemed to have been duly passed at the general meeting itself. So it will get the status as if it is passed in the general meeting, provided that the votes for assent is more in favor than the votes for dissent. So assent should be more than dissents in case of ordinary resolution. Okay, so the resolution is assented by the requisite majority, and for special resolution it shall be a 3/4 majority. So if you have requisite majority of assents, then it shall be deemed to be passed at the general meeting. I hope this is also clear. Now, once the company has sent the postal ballots and the shareholder need to reply, there is a time limit within which the shareholders will reply to the postal ballots. The time limit has been fixed as within 30 days of receiving or issue of notice. Issue of notice. Is it clear? If any assent or dissent is received after 30 days, then it will be considered invalid. It will be considered invalid. valid. Now this is clear. Now you have to note one more important point over here. This is like an exception. This is like an exception where companies do not require to transact any business, even these 10 business items, through postal ballot. If such company is a company in the nature of OPC, which is 1% company, which is defined under section 2 subsection 62. And if the company has up to 200 members, So if the company is an OPC or if the company has up to 200 members, then postal ballot is not required. I hope this exception is also clear to you. So far we have covered the question of when do we have postal ballot. Okay, we have covered why is postal ballot required. Second, we have covered when is postal ballot. Now the next question is how do we conduct voting? How do we conduct voting through postal ballot, which is covered under Rule 22. Rule 22, which is manner or procedure in which postal ballot shall be conducted as prescribed under Rule 22. Okay. So you are able to understand how I have bifurcated the provision into logical parts. This is how you have to learn law. You have to segregate it into logical parts. First of all, you have to ask the question, why is it required? When is it required? And how will you conduct it or operate it? Okay, let's go through how. See, first of all, the company shall give a notice to all its shareholders, along with the draft resolution explaining the reasons of such resolution, and if any documents is required which are material for the shareholders to arrive at a decision, that also has to be attached with the notice. The notice will request either an assent or dissent. What do you mean by assent? Assent means in favor, approval, and dissent means disapprove or against, in writing on the postal ballot, and such assent or dissent shall be provided within 30 days. We have already discussed that part. Now, the notice shall be sent like any other notice of meeting. It has to be sent by either registered post, speed post, electronic means, normally it is email, courier services, and the company also has to publish a public notice by means of advertisement in at least one English newspaper and one vernacular newspaper in the local language where the registered office of the company is situated and has a wide circulation in such kind of an area. Also, the company has to upload the same on the website of the company, if the company has a website. Okay, so you're clear about the first part of the procedure, which is notice. Okay, now the next part is, once the notice is sent, the postal ballot received by the shareholders, the board of directors have to appoint a scrutinizer. We have understood who is a scrutinizer and what is his role in our previous lecture of e-voting already. Now, who is a scrutinizer? He is the person who will oversee the conduct of this poll. Okay. Now, the scrutinizer shall not be in employment of the company. This is a condition, that the scrutinizer shall not be in employment of the company. Okay. And the board of directors should be of the opinion that the scrutinizer is well equipped and qualified to conduct such poll and conduct it in a fair and transparent manner. Okay, these are all points which were there in the e-voting provision also. Now, once the postal ballots are received from the shareholders, postal ballots are received from the shareholders, it shall be kept in the safe custody of the scrutinizer. The scrutinizer shall maintain the postal ballots received by him. He shall maintain the registers. He shall maintain the registers of ascents and descents, shareholders' details, number of shares of the shareholder, folio number of the shareholder, and all these documents shall be in the safe custody of the scrutinizer. It will also be his duty to ensure that no person shall deface. Deface means make any cuttings through which the assent or dissent will not be identifiable, or destroy the postal ballot, declare the identity of the shareholders. So the identity of the shareholders shall be kept confidential. Okay, this is clear. Now, once the postal ballots are received and are counted by the scrutinizer shall submit his report as soon as possible, but not later than 7 days. So, if the last date of receipt was, say, on this particular date, on a particular date, then the report shall be provided as soon as possible, but not later than 7 days. Not later than 7 days. So the maximum time is 7 days. It shall be given to the chairman of the meeting. Shall be given to the chairman. Then the chairman will declare the results, scrutinizer's report, on the website of the company. So results plus the report will be placed on the website of the company. This is the basic process which has been covered under Rule 22. Rule 22. Okay. I hope this whole process is also clear to you. Since we had already done e-voting process, this must have been much easier to understand. That is my hope. Okay. So, I hope you have understood this section 110 completely. It is an important section in which you have to understand why, for wider participation of the shareholders, when, if the business items are notified by central government or any other business items which are not ordinary business and not some business item where the director or auditor has to be heard, and such resolution which has been passed by postal ballot by the requisite majority of assents will be deemed to be passed in the duly general meeting itself. This is also clear. Then we had discussed it will not be applicable to OPC or a company with up to only 200 members. Then finally we had gone through the how part of it, that is how it has to be conducted, which is given under Rule 22, in which we had seen two parts of it. One was notice, the other was scrutinizer and results. So I hope you have understood this thing. If you have understood this section 110, also the voting part of it, then please do comment me in the comment sections and let me know in case you have any doubts or clarification. I will be more than happy to help you out on this. Also, if you have liked this lecture, if you have understood this lecture, please do like the video and share it with maximum of your friends so that this knowledge gets percolated to more students who are in requirement. Also, if you have not yet subscribed the channel, do subscribe the channel and stay tuned for many more such videos. Thanks a lot.